My name is Anna Zachariah. I'm a retired lawyer. I am doing a bit of social work. I represent OSCO, the Ontario Society of Senior Citizens, on the board of the Ontario Health Coalition. And Natalie has asked me to chair this panel discussion. And I want to say kudos to Natalie, who, though we call her the executive director, I affectionately call her OGL, our great leader, for the terrific work and the energy that she shows in setting up these things. So I know that Jane Meadus and Adrian and Gary Wills are here. And if they could start, I'm not too sure how that happens. This is the first time I'm hosting this.
Okay, so I'll just jump in here. So we'll start with Jane. Jane is a lawyer with the Advocacy Center for the Elderly. She is an expert on long-term care. She advocates for thousands of families and residents and their families in long-term care. And she has been a fierce in the best possible sense of the word, fearless advocate, and is a great friend. And thank you very much, Jane, for everything that you do. Your work has been instrumental in both shaping the analysis of what's happened during the pandemic and long before, and in working with us. You are, there are no words, I can't find words today, sorry, to describe just how important your contribution is. So thank you for joining us, Jane.
Well, thank you for that lovely introduction, Natalie. You know, this has been an extremely busy week with a lot of news around long-term care between the OLTCA going to the feds for liability coverage, the change or the introduction of legislation that would change liability for long-term care homes. We had the commission had their interim report come out yesterday. We had the marketplace piece last night, and then culminating in today. So it has been an incredibly long week. And I thought I would share a happy story because I don't think we hear enough of those. So I just wanted to share a bit of a happy story that happened at our office this week, which I think really talks about, you know, the issue of human rights in long-term care. We were contacted on behalf of a resident who was living in West End Villa in Ottawa. And as you may know, West End Villa has had numerous deaths over the summer from COVID. We were contacted by her prior to the outbreak in West End Villa. And this woman, who had lived in a long-term care home for quite some time for a variety of reasons, no longer wanted to live there. Her sister was able to take her home with her now, and she had been agitating and requesting to leave. The home had told them that she could not do so because the sister, there had been a power of attorney for personal care. However, it had been, there was a technical issue with it, and so they wouldn't accept the power of attorney that the sister had. And so they said to the woman, "We are making decisions for you and you cannot leave." There were discussions with long-term care homes. There were discussions with ministry prior to our starting, and they had gotten no farther along. We were retained, and my colleague Alyssa was the main person on this case. And you know, we gathered the information to make sure that the information that we had was correct. In the meantime, the COVID hit, and the resident came down with COVID. So things stopped. Obviously, she didn't want to leave during COVID. She did recover. And basically what we ended up having to do was just to tell the home that she was leaving on a certain day, and that her sister was coming, and that they were expected to have her ready to go. On Wednesday, she was picked up by her sister. She left. I believe she went to Harvey's for lunch, which was very exciting for her, and now lives with her sister in her home with no intention of ever going back to a long-term care home, COVID or not. I think what this case really shows is, the issues that we often see pre-COVID around long-term care, where people in long-term care are presumed incapable. There was no evidence that she was incapable, first of all, of making any kind of decision, especially with respect to leaving the home. There is no in fact, there is no issues around leaving homes. There is no authority for homes to detain people. She had every right to leave, COVID or not. Generally, substitute decision makers actually don't have authority to decide or not, so that was sort of irrelevant. But it shows the kind of control that long-term care homes often have over the people who live in them. And this has simply been magnified during COVID. We're seeing various issues that have resulted from the directives that we're seeing during COVID. And it's things that we saw before, but it's now magnified because of the restrictions that have been placed onto long-term care. Certainly one of those issues is detention in long-term care homes. As you know, in March, starting in March, the homes started to lock down homes, and they did two things. One was restrict visitors, and the other was restrict residents from leaving. This is being done via a directive from the Chief Medical Officer of Health. And in our opinion, it is illegal under a variety of different pieces of legislation, the Long-Term Care Homes Act, the Human Rights Code, and the Charter of Rights and Freedoms. The lockdown is not actually, in our opinion, legal. The rules under what the Chief Medical Officer of Health can do under a directive deal more with things like PPE, ensuring that staff are safe, that there's proper protocols going. They don't have detention authority under that section. And really what they've done is issued, a mass detention order for over 150,000 people in congregate care, whether they be in a long-term care home, whether they be in a retirement home, in some kind of group setting, without any legal authority. If the Chief Medical Officer believes that they should be detaining certain people, they can do that under Section 22, but it's a much more limited authority. It has to have much more evidence-based to do that. And the important part of Section 22 is it has a right of review. So if you are being detained under that section, you can appeal to the Health Services Appeal Review Board. The directive that they have, there is really no appeal process. You have to do potentially habeas corpus applications, and it's quite cumbersome. We've had clients, I certainly have a client who has left the home on a number of occasions. She's had the police called on her simply to go and pick something at a store locally. This is a huge problem. They're painting sort of with a broad stroke every person who lives in congregate care in Ontario. And that's not to say that there aren't risks to going out, that people don't have to be careful, but you cannot detain over 150,000 people in this way. And this has been a huge problem during long-term care, during the COVID outbreak. Another issue that we really have, obviously has been a big issue, is the issue of visitors. It's interesting that the Long-Term Care Home Act actually states in the residents' rights that the resident has a right to visitors without interference by the home. The question becomes, can the ministry or the Chief Medical Officer of Health interfere with those rights? Again, you have to balance some of that safety issues around visitors with what's going on in, with long-term care. But again, the problem is you have a piece of legislation which gives a person an absolute right to have visitors without interference, and it's being simply pushed away by a directive. And again, the legality of that is very questionable. Again, it's a human rights violation. You're specifically doing it upon age and disability, that you can't have visitors. The rest of us are sort of doing it on an honor system. Whether or not, we have visitors in our home is on an honor system. And it's understandable that in long-term care, there's certainly issues around congregate care and people bringing COVID in and trying to ensure that people are safe. Of course, the problem is that I don't think there's any evidence at this point that visitors have brought it in, nor evidence of residents having brought it in. We know that COVID is being brought in by staff members. And frankly, the rules around the staff members are less strict than around anyone else. If you look at the requirements, the residents must have COVID tests in certain situations. We all know that family or other visitors who want to have go in have to have COVID tests. Staff do not have to have a COVID test. It's not mandatory, and so staff can work in homes. They come and go during breaks. The things that are going on in some of the homes we hear about are quite disturbing from the residents about the lack of PPE, what they're doing, whether they're wearing it, coming and going. And it's really quite disturbing when you look at the directives and you see the pages of in either the directives or in the accompanying guidelines around visitors about how the if a visitor doesn't wear their mask, or if they touch the person's hand, they can be kicked out and have all these very strict things happen to them. Where really, what happens if the staff doesn't do it? Or what happens if the home doesn't comply? And that's the other thing that we're really running into right now, is the fact that the homes are being allowed to make up their own rules, and no one is really looking at those. The ministry's not looking at it. The chief medical officer, they don't really have any authority specifically to look at those kinds of directives. And it's very unlikely that the chief medical officer's health is going to be laying charges if a home has more strict visitor rules. And so we're having homes say things like, well, we've decided you don't need an essential visitor, so we're not going to allow it. Or we've decided we're not going to allow residents to go out because it's easier for us. And this continued problem of the homes having pushing down, or everything is being pushed down to the resident level. So instead of ensuring the safety on an overall basis with proper PPE, proper training, enough staffing, what they're saying is, we're just gonna, put you all in your rooms and prevent you from leaving. And this has been a huge, huge problem. And I know that Natalie is going crazy because I'm talking too much. So I am now going to, I'm going to stop. But I think that those, we're really, instead of providing proper care, proper funding, what we're saying is we'll just lock all the seniors up in their homes. Many have been in their rooms for months and months. We're talking not a few weeks. We're talking 6-7 months now. And something has to be done and something has to be stopped. And we're certainly trying to do that, but it is very difficult to pursue those things. And so I think that everyone really has to push that. And I can see a few faces out there who I know have been doing that on their own. And I really hope that everyone, whether you're an individual, whether you work in a union, whatever, is going to really push to try to have those things changed. Now I'm going to turn it back to Natalie.
Thank you so much, Jane. We're going to go to Gary Will next. Gary is a managing partner in the law firm Will Davidson Law. And this is a law firm that has filed numerous class actions, or is working on filing numerous class actions against for-profit homes during the pandemic. And he works with families to get justice for their loved ones in long-term care. So I think it'll be very interesting to hear from Gary Will. Thank you, Mr. Gary Will.
Thank you very much for having me, Natalie, and I'm very pleased to be here. So I must confess that I've been on a very steep learning curve the last 6 months about long-term care facilities. Before April of this year, I had never acted for a client in a long-term care home. I'd never been to a long-term care home, and I'd never known a person in a long-term care home. That's certainly changed up till now. Today, our firm represents over 1,000 residents and their families from long-term care facilities. And I've certainly learned a lot on this journey. So what have we learned? Now I can't advance my other. Okay, so we've definitely failed our seniors. There's no doubt about that. It's been a problem for decades, and what COVID has done is put a spotlight on the problem, and hopefully COVID can lead to some real positive change when it comes to our long-term care homes, so that we don't continue to fail our seniors. The very first case we had involved Lundy Manor, and the first call that I received from a resident at Lundy Manor, I evaluated the case, and this was early on. This was at the end of March of this year, and I determined that the cost of proceeding with an action for a single family would exceed the value of the claim, and we made a decision not to proceed with that particular claim. The calls kept coming in, and the problem kept getting worse. And I told my staff that we had to figure out a way that we could act for these families, because they were living under horrific conditions. So we decided to proceed by way of class action. So Lundy Manor had 19 deaths and 45 infections. And the next case was Orchard Villa, the largest number of deaths of any long-term care facility in the province, and 268 infections within that home. This is a facility that has 360 beds, so almost everybody within that facility was infected. The next was the village of Meadows, 21 deaths and 54 infections. Erin Mills Lodge, 21 deaths and 18 infections. Village of Humber Heights, 38 deaths and 22 infections. Holland Christian Homes, 12 deaths and 74 infections. This was one of the other homes that the Canadian military had to go in to bail them out, and is subject of a report that was released in May. Ballycliffe Chartwell Homes, 31 deaths, 78 infections. Ina Grafton Gage Home, 31 deaths and 69 infections. And then Seven Oaks, 41 deaths and 56 infections. So I want to drill down into one of the nursing homes, because in the interest of time, that's all we have time for. So we took a look at what happened at Orchard Villa. And before 2015, Orchard Villa was owned and managed by the LaFontaine family. And when I talked to our clients and their families, they say things were good back before 2015. The care was very well, and they unfortunately sold their home in 2015. And Southbridge Healthcare, which is a large American company, came in to take over at that point. And then Southbridge brought in Extended Care to manage Orchard Villa in 2015. Now, Extended Care has a very interesting history, because they are a very large multinational corporation. They've been in the healthcare business for many years, and they managed a lot of homes in the United States before 2012. And in 2013, the U.S. Department of Justice brought an action, a prosecution against Extended Care under the False Claims Act. And what basically they said was that they had billed Medicare for services that were so deficient that they were effectively worthless. And in October 2014, Extended Care paid $38 million to settle the case. It was the largest failure of care settlement in U.S. Justice Department history. And they also entered a 5-year corporate integrity agreement. And that was, they were going to be monitored for those 5 years on care that was being provided at healthcare facilities. And then about 2 weeks later, they sold their entire American portfolio for $870 million. And they said that their plan was they were going to come to Canada, grow and expand their business in Canada. And they made a major move into Ontario. And that was, they then were hired by Southbridge to manage the care at Orchard Villa. Now, Southbridge described extended care as a recognized leader in quality, clinically based services. There wasn't any mention about the record fine that they had paid the US Department of Justice. So what happens at Orchard Villa? So almost immediately, the complaints start. And the families that we represent said that the quality of the care deteriorated significantly.
We're down to just a couple minutes, okay? Sorry, Gary.
Okay. So a number of investigations were done. And these are there was warnings, there was plans of corrections. So the government certainly knew about all these problems. Doug Ford, when he had a press conference in May, and it concerned Orchard Villa and the military report, and he described the facts in the report as heartbreaking and gut-wrenching. And he promised that there would be a major investigation and that there would be accountability in the nursing homes and that there would be justice for the residents and their families. So as of October 2020, no charges have been laid, no one has been fined, no one has lost their job. And Bill 218, which was just released this week, now shields wrongdoers for responsibility for negligence. And this applies to long-term care homes. So, and justice for the residents and their families. The proceedings for negligence are now barred. If this Bill 218 becomes law, all existing proceedings for negligence are deemed to be dismissed without costs. And none of these residents or their families will get any compensation for the extinguishment and termination of their rights. Now, the government did say that they consulted with the public, but who did they consult with before introducing the legislation? They didn't consult with the Ontario Health Coalition. They didn't consult with any of our clients or their families, not with any legal organization, not with any consumer groups. They consulted with the Insurance Bureau of Canada and the long-term care homes and their lobbyists. And this is my final slide. This is a connection between the Conservative Party and long-term care home lobby. And it starts with Mike Harris at the top left, former premier. He's now the chair of Chartwell. His campaign manager, Leslie Noble, is a lobbyist for Chartwell. We have Ernie Eves, former premier, on the board of Central Park Lodges. Bill Davis, former premier, current board of Rivera, and it goes on and on. It's all laid out here, and there's actually more connections. I ran out of room on this particular chart.
Okay.
So I'll turn it back to Natalie. Thank you very much.
Yeah, thank you so much, Gary. Sorry that we are so tight for time today, but that was excellent and very helpful. Now, Adriel Weaver is here, I believe. Adriel, are you here?
I am, yes. Thank you, Natalie.
Okay, sorry. Gary, can you stop your screen share now?
Yes.
Thank you. And please go ahead, Adriel. Adriel is, sorry, I should introduce you properly. She's a lawyer at Goldblatt Partners, and she's got a broad litigation practice that includes criminal, constitutional, Aboriginal, and administrative law. She's appeared at all levels of the court, including up to the Supreme Court. She's worked with OCHU and the Ontario Health Coalition for months now, looking into human rights, discrimination against the elderly, and Ontario's healthcare cuts. Welcome, Adriel.
Thanks so much, Natalie, and thank you all for having me. I'm going to be speaking in very general terms today about the legal framework in which we might be situating these questions and debates, just to give us all the same general understanding. I'm sure many of you know much of this already, but I think it will help to set a foundation for discussions that continue today, both in this group and as you reconvene in plenary and also in other discussions. So the starting point today is the 2005 decision of the Supreme Court in Chaouli in Quebec. And while the court split on a number of issues there, the majority, and in fact all judges in different ways, affirmed that while the Charter does not confer a freestanding constitutional right to health care, when the government chooses to put in place a health care scheme, that scheme must comply with the Charter. So while there's no positive obligation on the government as such to provide health care, having assumed responsibility for doing so, it must discharge that responsibility in accordance with constitutional rights. Now in Chauli and in the much more recent Canby Surgeries decision, which I understand you'll be hearing more about later today, the focus was on the rights to life and security of the person. And those rights were ones that the court unanimously held to be engaged. As the late professor, renowned constitutional scholar Peter Hogg wrote about Chauli, as well as the earlier Morgenthaler decision, both cases decide that when the state assumes a monopoly power over the provision of a medical service that affects life or security of the person, it is under a constitutional duty to ensure that the service is provided in a timely fashion. What that means for Canada's public health system is that it is no longer constitutional for the provinces to ration healthcare resources by allowing dangerous waiting times to develop for procedures that affect life or security of the reasonable access to healthcare services that is required in theory by the Canada Health Act has become a constitutional obligation that is required in practice. Now, this conclusion has, in our view, clear implications for some of the effects on elderly Ontarians of cuts to healthcare spending that compound existing challenges of dehospitalization, extensive waiting lists for long-term care beds, and profound under-resourcing of long-term care facilities. So that's Section 7. Of course, there's a corresponding right under the Quebec Charter, which was the focus of many of the judges in Chauli. We also need to think about Section 15 of the Charter. And that, as I'm sure you know, provides that everyone has the right to equal protection and equal benefit of the law, without discrimination on a number of bases, including age. So Section 15 means that laws and government action in relation to healthcare has to provide not only reasonable access, as guaranteed by Section 7, but equitable access as well. And provincially, this is supplemented by the Human Rights Code, which provides additional protection from discrimination in the provision of services. And those services, of course, include healthcare. Courts have repeatedly held that both the Charter and the Code enshrine the principle of substantive rather than formal equality. So this recognizes that treating different individuals or groups of individuals exactly alike, as would be required under a formal equality framework, often in fact produces greater inequality of outcome. And accordingly, under Canadian law, equality rights protect not only against direct discrimination, but also against what is often referred to as adverse effects discrimination. So that occurs where a law or government program that is neutral on its face, nevertheless has disproportionately negative effects on certain members of society on the basis of one or more protected characteristics. So that's the overarching framework, both constitutional and provincial human rights law. What does that mean in relation to the impact of health cuts on the elderly? Well, first, that cuts that are made across the board or that are not explicitly intended to target the elderly may nevertheless be discriminatory in their effect. Similarly, the systemic under-resourcing of those aspects of the healthcare system that are disproportionately likely to be relied on by the elderly can constitute adverse effects discrimination and can be attacked under both the Charter and provincial human rights legislation. Second, and we've discussed this less, but I think it is of increasing urgency to think about the intersections of these rights as wait times for long-term care facilities continue to increase, and as the policy and the practice of dehospitalization become further entrenched, The right of the elderly to security of the person and indeed to life are increasingly engaged as well. We know that people are dying, waiting for long-term care beds to become available. We know that people are being discharged from hospital in circumstances where they do not have adequate care resources or plans in place and are readmitted to emergency because they have become unwell or injured as a result. So, yes, I'm just wrapping up. Thanks, Natalie. We're going to want to continue to think constructively and creatively about how we can use these legal tools to both safeguard and advance the rights of the elderly in the provision of healthcare services. And I'm delighted to be part of that process with the Ontario Health Coalition and its partners. Thank you.
Thank you so much, Adriel. I'm gonna just talk for a few minutes from our perspective from the Ontario Health Coalition and what we've seen in terms of systemic healthcare cuts that discriminate against the elderly in particular, and where I think we need to go on this. For decades now, the cornerstone policy of Ontario's healthcare system has been to cut hospital care. And there's no real way to understand what's happened in long-term care and home and community care without looking at the whole continuum of care, including hospital care. Starting in the 1990s, even before that, starting in the 1980s, the idea was that people should be enabled to age at home. And that notion in the 1990s became contorted into a way to cheapen healthcare, to cut healthcare costs by moving people out of hospitals first to reduce healthcare expenditures. Often you'll see comparators of the cost for keeping a patient in a hospital compared to a long-term care home, compared to home care. And many people take those just at face value, and they're repeated ad nauseum. But what we know is that the level of care is fundamentally different in hospital compared to long-term care, compared to home care. And what we're comparing is apples and oranges. Home care has been rationed, very severely rationed for decades now. Long-term care also increasingly has become very rationed. And in hospitals, all of your costs are covered, including meals and medication and so on. In the 1990s, they changed the rules to enable them to charge chronic care hospital patients co-payments for bed fees, and they offloaded patients by the thousands into long-term care and home care. The idea ceased to be that people should be supported, the frail elderly, et cetera, people with chronic illnesses, people with disabilities should be supported to live at home, and became an offload really to save money. By the mid of the first decade of the 2000s, this became more formalized. People who had previously been odiously called bed blockers were renamed alternate level of care patients. Those patients, about half of them are waiting for hospital care, for rehab, for palliative care, for convalescent care, for complex continuing care. About a third to a half at various times are waiting for long-term care, and at the smallest proportion are waiting for home and community care of various sorts. But that catch-all alternate level of care has been used as though it is tantamount to the person should not be in hospital. Increasingly, hospital executives talk about hospitals as only providing acute care. They talk about them as acute care facilities. But under the Canada Health Act and under the Public Hospitals Act in Ontario, convalescent care, chronic care or complex continuing care, rehabilitation, those are covered services and legitimate services for hospitals to provide. Nonetheless, the trend continues and has accelerated dramatically to offload those patients. Under COVID-19, they have been offloaded, what they call now decanted, I really find that appalling, into hospitals and for-profit retirement homes. Because there are 38,000 people on the wait list for long-term care homes, long-term care itself is severely rationed. And home care continues to be, although it has grown enormously as a sector, much of it now, about half, is taken with people who are post-acute or post-hospital patients getting wound care and so on. And the frail elderly have really kind of been pushed out the other end. And as it becomes more difficult to access home care, the acuity levels have increased. In order to get home care, it's increased and so on. What we see is this: there is no top level. There's no top bar for offloading a patient into long-term care. The acuity can be enormously high, and the facility can be completely unprepared to provide care for a person with that level of acuity, and still they're offloaded from hospital and considered to be long-term care residents. And the same happens in home care. There is no positive right to access home care under any legislation in Ontario. And so we're seeing an erosion of the Canada Health Act, which covers hospital and physician services, by moving where care is provided, by reducing the resources available to provide that care, and then and rationing, planned rationing of that care. At its very worst, in COVID-19, what it has meant is that people were left dehydrated, starving in long-term care homes. People were left in homes where COVID was spreading through the homes, and only ever 3 or 4 residents in total were sent to hospital to get care, even when the home could not provide the care. People were moved to their homes against their consent, without the right to consent, without adequate care. People have been moved to all kinds of private facilities, hospitals, hotels, retirement homes, and so on. And the policy of rationing access to care across the continuum, and that care primarily being care for the elderly, continues. We think this is a violation of human rights, and that it should be challenged, and we're working on how to do that. So I'm going to end there because we have a few minutes now for questions and answers. Anna, are you ready? We need to move through this fairly quickly. So we have about 10, sorry.
Yeah, I'm ready. My screen seems to have disappeared for a moment. Hold on.
Okay, well, let's move through the questions. You got the chat there. So if you have a question, if you can put it in the chat. If the speakers are able to access the chat and try to answer some of them in the chat as we're going. We have about 10 minutes for questions and answers. Anna, please go ahead. Thank you.
Who has the first question? My screen is out. I hope you can hear me.
We can hear you, but if you can't see your screen, I'll just do it. So I'm going to start with... Okay.
Yeah, I'm back. Okay.
Okay. Are you ready, Anna?
I'm ready. So I can't... Who was the first question?
Okay. I'll just do it, okay, hon? There are a lot of comments. Is there a template for a letter to long-term care for individual cases?
That was my question, yeah.
Okay. For individual cases regarding what?
Well, if we have an individual person, like a friend, not a relative, who's in long-term care, who's having problems, is there some sort of template letter that we could use, kind of fill in the blanks thing that we could use to write to long-term care? And who should we copy it to?
Okay, Jane, can you take that one?
Right, so you don't even have to write a letter. So if you believe that there is something going on in a long-term care home, especially if it's abuse, mistreatment, neglect, it's mandatory reporting under the Long-Term Care Homes Act. So anyone except for a resident must report any kind of abuse or neglect or mistreatment to the Ministry of Long-Term Care. There's an action line number where you can call, and if you just Google long-term care action line, you'll find it. You'll call, you'll get it. It's just a Service Ontario person who will take your information. Get sent to triage. Triage will take it, talk to you, and then depending on sort of what the issues are and everything, if it's something that the ministry does inspect on, it will be sent to an inspector. How long it takes the inspector to get in is a different question.
Okay, thank you. And then there's a question, does the provincial bill, and they mean Bill 218, mean that your class actions will be null and void, Gary?
No, absolutely not. What it does is it will eliminate any cases based on negligence, which is really the cornerstone of our legal system. But if you meet a gross negligence standard, which we will be able to, those lawsuits will continue on. But there'll be a higher standard of proof at the gross negligence level. So, I mean, we consider it unfair that these families will have to prove a stricter standard of proof. But so hopefully the legislation will be defeated. But in the event that it doesn't, these cases will proceed. No doubt about that.
And Gary, is anyone going to challenge, are there grounds to challenge this legislation?
Well, the challenge will have to be on a political basis. So I think there's going to be a number of protests. I think people can affect this by writing their MPPs. I mean, this is extremely unfair that the government is doing this. It's unnecessary. And to take away rights on a prospective basis, I mean, this takes away existing legal rights going backwards. And that's certainly unprecedented and very unfair. People should not lose their rights.
That's right. It goes back to March 17th, which is, I don't think coincidentally, the week that long-term care outbreaks started to spread. And then there's a question, how do constitutional rights impact the recent Ontario government's proposed restrictions on suing for compensation? Adriel, do you have any answer for that one?
I mean, it's not as though the government can contract out of its obligation to fulfill constitutional rights. It can't pass legislation that would do that other than through the use of the notwithstanding clause, and then that would be subject to limit. So it doesn't have an impact on constitutional rights. There's no limit to one's ability to bring a charter challenge based on that. So would there be a constitutional challenge to the legislation? That's a really good question. It certainly does affect legal rights in a retroactive way, as Gary has just described, and that is unusual. But at the same time, all of the ordinary constitutional routes to challenge various things would be available. It doesn't affect the Human Rights Code either. So if we're thinking about discrimination, for example, all of those claims would survive.
Okay.
It's an interesting question.
Yeah, for sure. And retroactivity means that the law, even though if it's passed, say, next week or the week after, it's retroactive to March 17th, which means the provisions in the law that was not in place March 17th and for all the months between then and now will now be in effect. So that higher bar, having to prove gross negligence for the plaintiffs and for the defense, the lower bar, the easier defense would be in place for all of the legal challenges that were underway starting from March 17th on. This one is for Jane. And it's our last question that we're going to be able to do, I think. Maybe one more. What legal tools can be used to stop the tragedy of secure units? I know you've talked about this, Jane. Prisons and long-term cares, these are petri dishes. We've been told by doctors that wanderers will be sedated, is the comment.
Sure. So it would be, illegal detention. Long-term care homes don't have detention authority, and our opinion is that the directives don't allow it either. And this is going back pre-COVID. So the Long-Term Care Homes Act does actually not allow detention in long-term care. There is no detention authority. So you could sue the homes. I think that there's potentially a case against the government for not enacting proper legislation. That would be more of a constitutional question that Adriel can probably answer. But the detention authority is in the books in the Long-Term Care Homes Act with the right of review. It's never actually been it's never been enacted. So it's what we call grayed out. So it's there, but it's not actually in place. So that's just in detention in general. But whether or not a person's on a secure unit or not, people are being detained in long-term care using the directives. And definitely we're looking for cases. I think it would be basically subject to a habeas corpus application with respect to what's going on right now.
Thank you, Jane. And Adriel, did you want to add in there?
Oh, I'm just nodding along. I mean, we've been doing this work in relation to actual prisons, but I think that the concerns are very much the same in locked wards, and I would be delighted to talk with Jane further about a habeas or similar application.
See, before the pandemic, Jane and I had talked for a number of years about these locked units or secure units in long-term care and in retirement homes. And I remember, Jane, years ago, you said to me, you know, nowhere else in our society do we allow for-profit companies to lock people up. That just doesn't happen. And then, you know, there's no rights advisor, there's no judge, there's no jury, there's no, you know, this is egregious and it can't continue. But I think it's the extreme end of the spectrum of human rights that are taken away from people when they go into long-term care and retirement homes that we really do absolutely have to change. Just the last question there for Mary McCarthy, for you, Gary. Will lawyers be protesting, sorry, I'm just scrolling up a bit. I lost it, sorry. Where did it go? Will lawyers be protesting the, I really lost it, the changes to the Act in Ontario, and do you have any sense of how?
Yes, absolutely. I mean, the Trial Lawyers Association was not consulted about the legislation before it was introduced, but we've been consulted, and we've now put in a brief to the Attorney General's office asking for significant changes in this law. So we will be protesting, but you always have to remember that whatever we protest, it will always be seen that we have some self-interest in this. So it's much more effective for groups like the Ontario Health Coalition and people that don't have an interest in these matters to protest, because those will be taken a lot more seriously. So if people on this line want to protest, you can write your local MPs, and I imagine there are going to be protests that are going to be organized. If you participate in that, use your media contacts to get the stories out, because this is a very unjust law. There's no doubt about it.
Thanks, Gary. So we will be joining us, some of the families, the Orchard Villa families and others, in some protests that are being planned around this. And also for everyone who's here, we will send you a very quick and easy way to send a letter or make a call to your local MPP and to the Attorney General and the Premier protesting this, so they hear a lot of noise on it. I'll let you know what the schedule is for the passage of the bill as quickly as we get that information. It hasn't gone for debate yet. I think it's up next week. And so we'll send that out to everyone who's here. Thank you. And thank you to the speakers. You're so succinct and really covered the ground amazingly well. And you are just, yeah, everyone's clapping. And you're just, it's such a distinguished, amazing bunch of human beings and professionals. We really, really appreciate your work.